Yes, Mr. Kenny.
My lady, you will have seen our skeleton arguments. You therefore know who is appearing in front of you. What I propose to do, what Mr. Eaton and I have discussed doing, is splitting the time available. So I will do my best to confine my submissions to this morning. He will do this afternoon, and we will divide tomorrow morning. In my submissions, what I propose to do is to start.
So can I just say, I haven't discussed this with others, but speaking entirely for myself, there's quite a lot of law in this, and I, for my part, will not be upset if you feel it necessary to use more of tomorrow than the first half of the day, particularly if we hold you up. Don't feel under undue pressure of time.
Okay. We'll just so I understand exactly how much of an inch I'm being offered to take.
Just pause for a moment. Yeah, we're all happy to sit tomorrow afternoon.
So you have tomorrow afternoon available?
We do have tomorrow afternoon available, and therefore if you feel the need to use half of that time, it won't upset us.
My lords, my lady, what I suggest, what I propose to do is just make a few introductory remarks, and then I will, in time-honoured fashion, deal with the facts of the case, the tribunal's decision, question of law on the Section 69 appeal, the authority that we say supports the tribunal's conclusion.
Is that authority in the singular?
Authority as a collective noun for a large assembly of cases.
Thank you.
But as you will have seen from our skeleton argument, we focus on 3 cases as having special.
It was a slightly facetious remark, Mr. Kenny.
The principles of justice, which we say also support, or the considerations of justice, which support the tribunal's decision, and then finally the objections and points against that have been marshalled against us by Mr. Eaton and Mrs. Justice Dias. Introduction. This is, we say, a case about the scope of the principle that a party to a contract can't take advantage of its own breach of contract. It's about how that principle applies, or as Mr. Eaton says, doesn't apply to the facts of this case. Specifically, the question on this appeal is whether the buyers in this case avoided incurring an obligation to lodge a deposit with a stakeholder by breaching another term of the contract under which they'd promised to help set up the deposit holding arrangement by providing all necessary documents to the stakeholder. Put crudely and simply, did they avoid an obligation to lodge a deposit by stopping the deposit holder from opening the account into which they'd promised to pay the deposit? Our submission is, our answer is no, and that is essentially because the buyers can't take advantage of their own breach of contract. Summarising the dispute in slightly fuller terms, in this case, the parties had agreed that the buyers, that is the respondents, would lodge a deposit with Holman, Fenwick and Willan. They had also agreed that the buyers would assist Holman, Fenwick and Willan to open an account into which the deposit would be paid by providing Holmans with any necessary documents. The buyers failed to perform that latter obligation. They just, in one case, didn't sign the necessary documents, in other cases didn't supply the KYC, know your client documents, that Holmans were asking them for. As a result, one of the preconditions to the buyer's liability to lodge the deposit with Holman, Fenwick and Willan was not fulfilled. That is, Holmans didn't confirm that the deposit holding account was open and ready for use. The question on this appeal is whether in those circumstances, i.e. where the buyers had prevented the fulfillment of the precondition that Holman Fenwick should have confirmed the account was open, whether in those circumstances the precondition is waived or dispensed with. With the consequence that the deposits fell due and the sellers became liable, exposed to...
Do you mean buyers?
Sorry, the buyers. And careful readers of my skeleton will have seen that's not the first time I've made that mistake, but for which I apologise. With the result that the buyers became liable or exposed to the consequences of not paying the deposits. In other words, the question is whether the buyers can say, were entitled to say in front of the tribunal, because we didn't supply documents promptly, Holmans didn't confirm the account was open, and because Holmans didn't confirm the account was open, we never had to pay the deposits. The tribunal held that they couldn't say that. The judges held that they could. And on this appeal, we say the tribunal was right and the judge was wrong. Now, I just, finally, before getting on to the contract, just want to put in context why this matters by reminding you, or at least repeating again, how this fits into the provisions in the MOAs concerning the termination of the MOA under clause 13. If, let me put it in this way, all of this matters because of the consequences that follow from a failure to lodge the deposits. If the obligation to lodge the deposits fell due. If, as we say, deposits fell due at some point during May, despite the buyer's failure to supply documents, then once those deposits had fallen due, the buyers had failed to and were in breach of their obligation to lodge the deposits. The result of that, their failure to lodge the deposits, was that the sellers were entitled to terminate the MOAs when and as they did at the end of May or in early June.
Is it part of your case to establish when the deposits fell due?
It is only necessary that the deposits should have fallen due before we purported to terminate.
Right.
Now, I will address in due course, but I'll address briefly now what we say about that. The answer is that the breach of contract consisting in not supplying documents gives rise to a waiver, or it may be an estoppel, or it may be a deemed satisfaction. There are various juristic ways of characterizing it, but let me just stick, as the tribunal did, with waiver. Gives rise to a waiver. And when does that waiver take place? It occurs when there is a breach of the obligation to supply the documents. And at that point, in effect, the buyers are saying, don't worry about clause 2.2. We're not insisting on that. So at that point, at the point that there has been a breach, the requirement that Holman's give its confirmation is dispensed with. And that means that the deposits fell due at that point. The other way of looking at this is a sort of slightly more
Before you come on to the other way of looking at it, that requires you to establish when they ought to have provided the information. Is there an issue about that? Or
There's not. They failed to do it by the time that we purported to terminate. So by the time we had purported to terminate, they had failed to provide the information. They were in breach of their obligation to pay the deposits, so that at the time that we terminated, we were able to say, you should have paid the deposits, you haven't, we're terminating. The other more legalistic way of looking at it is to look at it in terms of pleading, and that doesn't require you to identify a specific moment, because the way the case is pleaded is we plead, you didn't pay the deposits under clause 2. They plead in defence, well, I didn't have to, because Holman, Fenwick and Willen, a precondition wasn't satisfied. Holman, Fenwick had never confirmed that the account was open. And we say in reply, oh, but you're stopped from relying on that point, or you've waived that requirement, and therefore the non-applicability of clause 2.2, the clause 2.2 requirement, is determined at the point of the resolution of the dispute. It doesn't require a sort of a real, an historical moment at which the obligation to lodge the deposits became effective. It's only established, as it were, with retrospect in the pleading process that they're unable to meet our reliance on clause 2 by saying that the precondition was not satisfied. And I offer those as two equally sensible ways of describing the mechanics of the case.
But they both depend upon breach of the obligation to provide the documentation.
Absolutely.
Having occurred prior to your termination.
Absolutely. I mean, that's the simple point. If there's been a breach of the, and we'll look at the award in a second, but essentially the finding of fact the critical finding of fact in the award was that the reason that Holman, Fenwick and Willen didn't give their confirmation was because the buyers had failed to supply the relevant documents. That's paragraph 21 of the award, I think. Just confirm that. And what's interesting about that is that we'll look at causation later on, but this is one of the few cases in which there's been a real issue about causation, because there was a dispute about causation before the arbitrators. Because before the arbitrators, the buyer's case was, our failure to supply documents didn't cause Holman, Fenwick and Willan not to give its confirmation, because you were also in breach. And the arbitrators resolved that as a question of fact and resolved it against the buyers. And so the critical passage, so taking it slightly out of order, I will take you there. It starts at, this is in the appeal bundle, tab 7, page 79. Starts at paragraph 17, and the tribunal say, as to the second argument, this is the buyer's second argument, that it was not only the buyers that failed to provide Holman, Fenwick and Willan with documentation necessary to open the account. Irrespective of the buyer's content, the sellers were also in breach. First of all, they explain what the necessary documentation was. As appears from the pleading, the opening of the escrow account proceeds in 2 stages. First, KYC documents, then the complete services agreement or escrow agreement for signature. And then, I won't take you through this blow by blow, but essentially the tribunal in 18, 19 and 20 look at the pleaded case with respect to each of the relevant MOAs. And in 21, critically, this is the factual finding that underlies this case. Drawing all these points together, we are satisfied that on the face of the pleadings, we can and should proceed on the basis that the seller in each case did not breach any obligation under clause 2 with regard to the provision of relevant documentation to enable the escrow account to be opened, and that on the contrary, it was the buyer in each case who had, in breach of clause 2, failed to provide the necessary documentation to enable the escrow account to be opened without delay.
It's those words without delay, which is what I was sort of grasping towards, which is, when do you say they should have provided the documentation? Your answer is, well, we don't need to say on this day, but we've got a finding of fact that they didn't do it timelessly.
Exactly.
And that's enough.
Exactly.
Yes.
And the without delay is, we'll look at the contract in a second, but that is picking up the words of lines 41 and 42 of the MOA, which impose on them an obligation to supply documents without delay. So that is just a finding that their duty under lines 41 and 42 was not complied with.
Yes, they must have some time to assemble the documentation and send it to Herman Phoenix.
Yeah.
But it'd be a matter of a day or two.
I mean,
it
in
shouldn't take a long time.
In another case, one might say, we would say, well, in breach of lines 41, 42, you failed to supply without delay. And they might say, well, at the time that you treated the deposits as having fallen due and purported to terminate, you'd only given us 48 hours, and of course, we hadn't got it out of the file yet. But in this case, the MOAs were signed at the end of April, and the MOAs were cancelled under clause 13 for failure to pay the deposits at the end of May. They had a month. And nobody ever suggested on their side, and indeed this finding of fact is inconsistent with any such argument, that there had not been a failure on their part to comply with their contractual duty to supply documents without delay.
Am I right in thinking this partial award is not after hearing evidence? It's on the basis of pleaded cases, is that right?
On the basis of pleaded cases. So we proposed an award to be made on the basis of identified preliminary issues. That award to be made on assuming that all the facts pleaded by the buyers were true. So when they reach conclusions of fact, that is on the basis of those conclusions of fact that can be founded on the parties' pleadings. And of course, it would be open to someone to say, well, hang on, you couldn't have found that as a fact because that wasn't open to you to derive from the pleadings. But no such argument has been made. Okay, so I was just...
You were dealing with why it matters.
I was dealing with why it matters and saying it matters for two reasons, or it matters essentially because of the consequences of the conclusion that the deposits fell due as deposits. And the first consequence was that having failed to lodge the deposits, we, the sellers, acquired the right to terminate under clause 13. So one of the grounds of which we're entitled to terminate, we have contractual right of termination under clause 13. One of the grounds is the buyers have failed to lodge the deposits. And that is important because we did terminate, and because whether we were lawfully entitled to terminate is very much an issue. The buyer's case is, well, you weren't entitled to terminate because you had no right under clause 13 because the deposits had never fallen due, and you were not in, we were not in common law repudiatory breach because we were trying to sort out the management agreement. It was all very difficult. So our right or not to terminate under clause 13 is a critical part of certainly this award, which says we're entitled to claim the deposits because we lawfully terminated under clause 13, but more generally in the dispute to establish our right to terminate the MOAs. And then second,
Does it matter that it has to be a termination under clause 13 if the Griffin is rightly decided, then failing to pay the deposits, if they're due or deemed due, would be a repudiation of common law as well? And you, as I understand it, you purported to terminate for repudiatory breach as well under clause 13.
we did, you're right, but
And how does clause
and
21
I
affect that?
I of course have to recognise good points lobbed at me from the bench, but that common law right to terminate for payment of non-payment of the deposits is just the same corollary, or is also a corollary of the deposits having fallen due. And
Yes, that's why I wondered why you spoke of it as being important.
Well,
I referenced your right to terminate under clause 13. It's important for your right to terminate at common law or under clause 13. Is that
a better way of
is that a better way of putting it?
Yes. And then secondly, the right to terminate founds the claim that we made and which succeeded in front of the tribunal, which is the claim for payment of the deposits as a debt. And I'm going to say it when we get to it. It's very important not to collapse the two stages that our claim involves. We rely on the abacha principle to establish that the deposits fell due as deposits payable to HFW. All right, that's step one in the claim. We say what you the buyers can't deny is that, or can't set up, is the failure of the precondition to your obligation to pay a deposit to HFW. We don't say, and that's the point at which we take out of our toolbox the abacha principle and say, this is the relevant principle to resolve whether you can deny your liability to pay the deposits to HFW as a deposit.
It would then be held in escrow, and that by itself would not entitle you to judgment for it as a debt. You have to rely on the non-payment as giving you the right to terminate and then claim it as a debt.
Yes, so it falls due, they then haven't paid it,
Yes, falls due, but not due to you as a debt, due to
Not due- exactly.
HFW in escrow,
It's,
at which point you may never get it. If they'd actually paid it,
if they'd actually paid it, which of course they didn't. But yes, I mean, if and again,
well, this is the golden victory point. If they'd actually paid it, you might never get it because the contract might go off for reasons that weren't their fault, and they might get it back.
Yes, but only if they had paid it.
Yes.
But I just at this stage, I'm only making the simple point that we don't say in any way that somehow we can rely on Abacha or Panamina without more to convert their obligation to pay the deposit as a deposit into a debt to us. Abacha is applied at stage 1 to say, no, you had an obligation to pay the deposits to the deposit holder. We then plead and rely on the fact that they, being under that obligation, failed to discharge it. In other words, they didn't pay when it fell due in early May. We then say, because you didn't pay, we now cancel that common law or under clause 13, and we forfeit the deposits. And what we're claiming now is the forfeited deposit.
Sorry. I mean, there are two slightly separate points, are there? One is that on the face of the MOA, the obligation to pay the deposits was not an obligation to pay them to you,
Yes.
but to pay them to Holman, Fenwick and Willen as stakeholders.
Yes.
And so far as that is concerned, despite the fact that they're payable to Holman, Fenwick, Willen as stakeholders, the Griffin establishes, at least up to the level of this court, that doesn't prevent it being a debt owed to the sellers. And therefore, the fact that the deposits would have been paid and are deemed to be paid under the Abacha principle, or deemed to have fallen due under the Abacha principle for payment to Holman, Fenwick and Willen, doesn't prevent them being an accrued liability in debt owed to you. That's one point. As I understand it, the golden victory point is a slightly different point, which is if the claim had to be framed as a claim in damages for breach of the obligation under clause 2 to do all that's necessary to enable the escrow account to be opened without delay, there is a golden victory objection to the amount of the deposits being the measure of the damages, because it is said, had that happened, had they been paid into escrow, when it then came to the mechanism of release, because of events which had subsequently taken place, they would have in fact been released back to the buyers, not to the sellers. Have I understood the golden victory point that was being taken anyway?
Yes, subject to Mr. Eaton confirming that's how he wants to put it. But
yes, that's absolutely right. There are two aspects to it. And the first aspect is the one your lordship said. If they have to claim in damages, the damages are nil. And that's why we're all arguing about whether they've got a claim in debt. I mean, it probably in 7, 8, 9, 10 cases where it's a dispute about promissory precondition to the accrual of a debt, it won't matter whether the claim is in debt or in damages. In this case, it is critical. That's why we're here. And the second point is we submit that the golden victory shows why the Griffon is wrong. And the Griffon assumes
that you may or may not be right about that, but I'm not sure that's a debate that we can enter into in this court.
But that's the reservation of rights that we make to take that point further, and we do submit that as my lord was saying, the claim assumes that they'd have got the money if we'd lodged it with HFW, and we say, well, that they wouldn't. So why do they get it?
Thank you. I was just trying to short circuit you slightly. I totally understand why the claim in debt is advantageous over a claim in damages, which for the time being, because it's been remitted under Section 68, is a live issue in the arbitration.
Yeah. And picking up your 2 points, first of all, the Griffin, I don't want to get into the Griffin because you've rightly said this is not a point for this court. But whether the Griffin is right or wrong, the two stages are the same. Initially, their obligation was to pay the deposit to HFW, and query whether that was actionable by us. We would say it was actionable, but in terms of an order, we would get an order for payment to Holman, Fenwick and Willen if we had pursued it before cancellation. But what's critical is, after we've terminated and forfeited, then the debt that was previously payable to Holman, Fenwick and Willen is payable to us. And that's the critical conclusion in the Griffin that we rely on.
And that's the, sorry to
Yeah, yeah.
divert you, but that's the part of the Griffin, is it, that says that's because that's the effect of clause 13,
Exactly.
in which compensation includes the deposit.
Exactly.
Yeah, whether or not, although the Griffin also treated the debt as an accrued right at common law, which was unaffected by the termination, which must then have treated it as a debt due.
It was actionable before, but upon termination and forfeiture was recoverable by the sellers, even though obviously it hadn't been paid.
But I think the Griffin proceeds on both bases in the alternative.
Yes.
A, it had accrued as a debt due to the sellers prior to termination, and therefore termination doesn't affect accrued rights, and at common law there was an entitlement to it. And secondly, in any event, if the termination was pursuant to clause 13, the rubric in clause 13 about being entitled to compensation was wide enough to include, but not be limited to, the deposits.
Yes, precisely.
Both it was both those aspects which were not defeated by the fact that the contractual obligation was not to pay the deposits to the sellers, but to pay them to a third-party stakeholder.
Yes. All right, and then on the Golden Victory, of course, you're right. You characterise the argument exactly as it's put, that if the proper counterfactual is that they had supplied documents and then they had subsequently continued to perform all their obligations, including actually paying the deposits, then full performance by the buyers of their obligations might ultimately have brought us to an end point involving frustration or some sort of discharge without fault, in which they might have had returned to them the deposits that they paid. But, of course, our argument on damages, not before this court, but our argument on damages is, no, the proper counterfactual is not to assume that you'd continue to perform all your obligations until kingdom come. Proper counterfactual is to work out what would have happened if you had complied with the obligation that we complain about you not performing, i.e. supplying documents. And we say that what would have happened is Holman Fenwick would have given their confirmation, the deposits would have fallen due, the buyers wouldn't have paid the deposits, and we would have cancelled. That's why our damages are in the amount of the deposits that, on this hypothesis, they prevented from falling due.
Yes.
And we say that conclusion is consistent with the Blankenstein, where the disappointed sellers recovered as damages the value of the deposits that hadn't been paid.
Well, as you said, that's all a matter for the arbitrators.
Yes.
Uh,
Right. But just so you've got so you have the context.
Thank
All
you.
right. Let me come on to the relevant contract terms. We find them in the appeal bundle at the last tab. This is, as you will have picked up, one of the 3 MOAs. And for present purposes, the crucial term is, the first crucial term is 5A, which is at page 149. Which requires that the vessel be delivered and taken over safely afloat at the end of its current voyage in Singapore, and which then envisages that delivery will take place sometime between the 4th of May and the 31st of May. And the other 2 MOAs were, though providing for delivery in different places and at slightly different times, broadly in the same terms. The second critical term is page 148, clause 2, and that requires, as security for the correct fulfilment of this agreement, the buyers shall lodge a deposit of 10% of the purchase price in an account for the parties with the deposit holder, that's Holman Fenwick, within 3 banking days after the date that 1, the agreement has been signed, and 2, Holman Fenwick has confirmed in writing to the parties that the account has been fully opened and ready to receive funds. And then, critically, lines 41 and 42, the party shall provide to the deposit holder all necessary documentation to open and maintain the account without delay.
Is there any significance to the bold and italicized parts of the contract?
The bold and italicized parts are the bits that have been written in by the brokers.
Right.
They're
Not
the
the titles, I should say, but where, for example, you see
Where it says
in-
fully opened and ready to receive funds. So,
yeah, and ready to receive funds has been added by the parties.
so the Shipbrokers Association form just says has been opened.
Yes.
Yes, I see. Thank you.
The contract doesn't. I should say this, that Mr. Eaton says in his skeleton, and the judge had in her judgment the proposition that there were 4 preconditions to the obligation to pay the deposit. And it may not matter greatly because there's only one precondition that really matters, but our submission is, no, there are 2. The first is clause 2 Roman 1, signature, and the second is clause 2 Roman 2, i.e. Holman Fenwick's confirmation. The supposed intermediate, what the judge called precondition 2, was the supply of documents. And we say that may have been a practical necessity, but it wasn't a precondition to the deposits falling due. I mean, one simple way of testing that would be to say, suppose there had been no, I'm going to get myself into trouble. I would just simply say it's a practical necessity rather than something that is specified by the terms of the contract as a precondition, a necessary precondition to the deposits accruing due. The fourth of the judge's preconditions was the lapse of 3 days. And that we simply say is just misreading the clause. What it says is that after the 2 conditions, Roman 1 and Roman 2 have been satisfied, the payment has to be made within 3 days, not after the lapse of 3 days. But anyway, not a great deal turns on that. necessary documents, you have already seen what the tribunal said about that at paragraph 17 of the award, i.e. they were the KYC documents and the signed escrow agreements. The facts of the case we've touched on in the course of exchanges we've already had. The Alina MOA was signed on the 29th of April. The other two relevant MOAs on the 28th and 30th of April. That's in paragraph 4 of the award. The tribunal recognised in its findings at paragraph 14 of the award, so this is page 77 of the bundle, that it was an essential part of our case that the reason why the escrow account was never fully opened was because of what we say was the seller's breach of the buyer's obligation, the buyer's breach of what we say is the buyer's obligation under clause 2 to provide the necessary documents. At the hearing, as we've already seen, there was an argument about whether the failure by, or the non-fulfillment of the condition that Holm and Fenwick should give their confirmation was caused by their failure, or whether in fact we were also in breach. And that, you've seen, was resolved in paragraph 21 of the award, page 81. What happened following the buyer's failure to provide documents promptly obviously depends on the answer to the question in this appeal. The buyer's case is, as you appreciate, I'm sure, that because they hadn't provided the documents and because Holm and Fenwick hadn't confirmed that an account was open, the precondition in clause 2.2 was not satisfied, and their obligation to lodge the deposits just never accrued. Our case, which the tribunal accepted, was that even though Holm and Fenwick had not given their confirmation, because it was the buyers who prevented Holm and Fenwick from giving that confirmation, the buyer's obligation to lodge the deposits with Holman nevertheless fell due, and the tribunal accepted that at paragraph 36 of their award. Our case, therefore, at a time that doesn't have to be precisely identified, but before termination, is that the deposits had fallen due, and therefore we were entitled to terminate. And on 22nd and 30th May, the sellers purported to terminate the MOAs in the Alina and the Macronesus, relying on both, as my Lord Justice Popplewell has observed, both clause 13 and common law repudiation, and that was held to have been lawful termination by the tribunal in paragraph 36.6. In the case of the third ship, the Astari, slightly more complicated because the buyers purported to terminate first, and the sellers then responsively purported to terminate, but again, the tribunal's conclusion was that the sellers were entitled to terminate as they did on the 9th of June, and that's paragraph 36 Roman 4c, page 95 of the bundle. And then following...
Just give me that paragraph number again.
36 Roman 4c. The tribunal's sub-numbering has eventually run itself into the sand,
So what page are you on?
So this is page 95.
Yes. Thank you.
And I say it's 34 Roman 4C. Actually, apologies, it's Roman 9C. Yes. And the bit of it is my attribution of it to C is possibly doubtful in as much as the margin has moved. but it's
May
fine.
just be the conclusion to the whole of paragraph 36. No. Anyway,
And then, as we've already touched on, it was assumed for the purposes of this award that the ships were sold by us at a higher price than they would have been sold to the buyers, so that on the resale, or by reason of the resale, we suffered no loss. There's an underlying issue as to whether that's the case, but the award proceeded on the assumption that that was correct. And our riposte, therefore, on damages is, as I've outlined, yes, but our damages is the amount of the deposit you should have given us and failed to give us.
If it is a question of damages, is there any issue as to whether you have to give credit for the extra price you got on the resale?
Yes, it no doubt would be an issue. And therefore, when I say our damages are the value of the deposit, that is our loss, I should say. Our damages would be a net figure taking account of our position, but we say first entry in the ledger, the value of the deposits. Okay.
In which case it might make a difference even on your case, whether it was a claim for debt or damages. Because when you addressed us earlier, you said you had a claim for the amount of the deposit even if it was a damages claim.
And you're right that the I fully accept that point. All right, I come on now to the tribunal's decision.
Sorry, just before you do so, can I just be clear? The breach of clause 2 obligations by the buyers you rely on are in 2 of the 3 cases failure to supply KYC documents,
Yes.
and
In the,
all 3 of the cases also failure to sign the escrow agreement.
I would have to take instruction on whether in one of them whether in either of the cases where they didn't supply KYC documents they had signed the escrow.
Agreement.
But I
So-
can put
so-
it this way: in 2 of the cases they didn't supply KYC documents, which was fatal.
And in the third case,
And
they
in the
didn't
third
sign
case
the
they
escrow
didn't sign,
agreement,
which
but-
was also fatal.
But the award doesn't disclose whether they signed the escrow agreement in the other 2 cases.
Yeah.
Is that right?
And I'm being sagely reminded by Mr. Hain that what the tribunals say is in paragraph 17 is that it's a sequence, that you supply the KYC documents, and once they're satisfied on KYC, they then circulate the escrow agreement. So I think you can infer that where they have not supplied the KYC documents, you just never get to the point at which there's any possibility of circulating an escrow agreement for signature.
I think they say that expressly in 20 in relation to the Astari and implicitly in 19 in relation to the Macronesos.
So that's not a separate breach in those 2 cases where they didn't supply the KYC documents, because
So
there was never an escrow agreement for them to sign.
no, because the consequence of their initial breach in failing to supply KYC documents was that the stakeholder never got to the point of providing them with the document for them to sign.
Yep, thank you.
Okay, so one gets on to the award and the tribunal's decision on the critical question that you're going to resolve in this case. And tribunal's decision, its recognition and application of what we've called the abacha principle, is awkwardly spread across two issues. But one finds it in the reasons of the majority at tab 7, page 85. Where, at the bottom of 84, one sees they're now turning to issue 2. Are the buyers liable because they cannot rely on their own breach of contract preventing the fulfillment of a condition precedent to payment? And their conclusions are in paragraphs 28, 29, 30, 32, 4, 33. So the critical passages are in 28. It's our conclusion on the basis of the pleadings that it was the buyers who had, in breach of clause 2 of the MOAs, failed to provide the necessary documentation to enable the escrow account to be opened without delay. On this basis, the sellers submit that the buyers can't rely on their own breach of contract preventing the fulfillment of condition precedent to payment. 29, in support of that submission, sellers rely on what they say is a general principle, viz. Where 1, a party breaches his contract, and 2, as a result of that breach, and we'll come back to causation, but it is important just to see how the tribunal were formulating that principle. As a result of that breach, a precondition to the accrual of a debt that he would otherwise owe to his counterparty is left unsatisfied, and the relevant precondition is deemed to be either waived or satisfied, and they refer to Mackay and Dick, abacha number 3, and Leonidas, where as they say, as Justice Foxton had reviewed the earlier case law. According to the sellers, this is in 30 now, the justification for this principle is that a person should not be permitted to derive an advantage from his own breach of contract. And then at 32, jumping on to 32.4, tribunal say the general principle that a party can't rely on her own wrong is well established and confirmed in the authorities cited by the sellers, which we readily accept. Accordingly, 33, we would answer issue 2 as follows. The buyers can't rely on their own breach of contract preventing the fulfillment of a condition precedent to payment. And then they go on, as they will deal with the consequences of that under issue 3. And then issue 3 is, are the sellers entitled to a final partial award for the amount of the deposit? And the crucial passage starts at 36.1, so that's page 90 of the bundle. In our view, the decision in abacha confirms the principle summarised above. There's, and then this is the same wording, 1, where 1, a party breaches his contract, and 2, as a result of that breach, a precondition to the accrual of a debt that he would otherwise owe to his counterparty is left unsatisfied, then the relevant precondition is deemed either waived or satisfied. Whether that principle may at some time in the future be reviewed by the Supreme Court is a matter of speculation. However, regardless of any criticisms, that principle is now well established and one we readily accept. Then 2, Roman 2, on this basis we accept precondition in clause 2, Roman 2, to the payment of the deposits, i.e. that Holman Fenwick has confirmed the escrow account has been fully opened and is ready to receive funds, must be deemed to have been waived or satisfied. All right. The section 69 question. The question of law is identified in the buyer's claim form at tab 5, page 55, and then repeated in the order that Justice Dias made in the commercial court at tab 3. The question is, when you read it in the order of the claim form, where an obligation for payment within a contract is contingent upon the fulfilment by one party of a condition, and that party fails in breach of contract to fulfill the condition, is the condition deemed to be fulfilled with the result that the payment sum can be claimed by the other party in debt, or must the claim be in damages? Now,
I'm sorry, I'm just catching up with you. Just to give me
so I
where
was
we find
reading
the
that.
section of the point of law as defined.
I was reading that from tab 5, page 55, under heading B,
Yes, thank you.
the question of law, which is the subject of the Section 69 appeal.
That doesn't seem to be quite the question of law that you're arguing.
I was going to make that comment. I mean, there are a number of points. I mean,
Well, the one that I had in mind is that the way in which you've opened it to us, the condition precedent which you want to be deemed to be fulfilled, is that HFW confirm the account is open.
exactly.
And that's not an obligation on the defendant, but this talks about an obligation being contingent upon the fulfilment by a party of a condition. HFW aren't a party. So are we able, on a Section 69 appeal, to decide a point of law that's not the point of law for which leave has been given? I mean, it seems to be unfortunate having got to this point.
The answer to that is obviously you must decide the question, but obviously you must give this a sensible interpretation in the light of the actual award and the way in which the case has been presented. But I make exactly that point, and it may be, if you are seriously troubled about that, that we might have to come back to that. But can I just make a couple of points along those lines?
There are a number of authorities, both at first instance and I think in a case I was involved with, I adopted them, Mr. Justice Hamlin and Mr. Justice Eder, that provided that the point is within the spirit rather than the letter of the point of law for which permission has been given, it is permissible to determine it. And the court quite often does so as arguments move on and refine themselves somewhat. It may be we're in that territory.
That was very much where I was expecting to park my bus.
Afraid I've forgotten the names of the cases, but
yeah. But let me just say that we identify the contiguous borders of the letter and the spirit. Make a couple of points about that question, and the first has been articulated probably better than I did in my note by Lord Justice Nugee. Contrary to first point, contrary to what the question implies, the relevant precondition in this case was not a precondition that the buyers had to fulfill. The relevant precondition was that a third party, Colin Fennick and Willan, would provide a confirmation that the account was open. The buyers, of course, had an implied obligation to cooperate to ensure that they did that. That's the other principle for which Mackay and Dick is authority, the implied duty of cooperation, and an express obligation to provide any necessary documents.
You don't really need the implied obligation to cooperate.
No, all right, no, all right. I mean, but
and,
all I'm saying
and you don't have any finding that it arose in the particular circumstances of this case.
I accept that. All I'm saying is that the extent of their obligation was, and perhaps you would say, and I accept, relevantly the extent of their obligation was to provide necessary documents, which they didn't do. But the only point is that it wasn't the buyer's duty to give the confirmation. The second is that the question implies, at least in this case, that let me put it in this way. Contrary to what the question implies, at least in this case, deeming the precondition to be satisfied does not have the direct or immediate effect that a payment sum can be claimed in debt. As I said earlier in the way I opened the case, the seller's claim in debt accrued in 2 stages.
Yes. So your case is there is an obligation for payment within the contract contingent upon the fulfilment of the condition precedent, namely the obligation to lodge a deposit with HFW.
Precisely.
That does not in itself give you a claim for debt. It's the subsequent
Precisely.
exercise of your right to terminate on failure to lodge a deposit, which then enables you to claim it as a debt.
Precisely. Yeah. So what the tribunal were holding by applying the abacha principle was that the buyer's obligation to pay HFW was effective. We weren't holding that we had, without more, a claim in debt.
That's exactly what they say on page 91, paragraph 36, little 3. Having said that the condition must be deemed to have been weighed or satisfied, this does not necessarily mean the sellers are entitled to the deposit.
Precisely.
And that depends on whether you confirm it.
Yeah. All right. So just again to clarify the this is one of those exercises in dissecting someone else's drafting, where I will sort of mop my brow that it wasn't me that drafted this question, but just so that we're clear about the limitations of the question, I think it's worth identifying these points. All right, third comment. Contrary to what the question implies, deemed fulfillment is not the only way of describing the effect of the abacha principle. There are at least two other ways of describing the effect of the principle on the assumption and basis that it is a rule of law. One is waiver, and the other is estoppel. In their reasons, the tribunal referred to either waiver or deemed satisfaction. They hedged their bets. You see that all over the award, but you see it, for example, at paragraph 29 of the reasons. The same principle, we say, has also been described as operating as a form of estoppel or quasi-estoppel. And that was the terminology used by the Master of the Rolls, Lord Justice Donaldson, in Corey, paragraph 20, and I won't take you there now, but we'll get onto that.
Can I just ask, as between those various alternatives, whether they seem appropriate might depend on the facts. So here, the precondition is the solicitor's firm having the right documents. The way the solicitor's firm operates, it wouldn't actually be able to accept a deposit into its account without those documents. So waiving that, the concept of waiving that precondition is quite an odd one.
Can I?
And actually, satisfaction is also quite an odd one.
Well, can I answer that by inviting you to consider what the consequences of the deposits falling due were. So let's just assume that, as I put it to my Lord Justice Nugee, the relevant waiver or dispensing with takes place after a reasonable time, perhaps a week or two, so that it's dispensed with at, say for argument's sake, the 7th of May. And on that date, we apply to the arbitrators and say we want a declaration that the deposits are now due. The buyers would say, but the stakeholders haven't opened the relevant account and we can't pay it. That's the oddness that, my lady, you're identifying. We would say to that, by your own default, in failing to provide the documents, you've simply put yourself in the position that you are now under an obligation that you cannot perform. But there's nothing unusual in commercial life about that. If I promise to sell you a cargo of wheat, but I have no wheat in my warehouse, I'm just unable to perform it. So the analysis is, on the day that the deposits fell due, if they'd suddenly suffered from a dose of compunction and thought, God, I must put my house in order, they wouldn't have been able to pay immediately. But what they would have had to do was to say, right, let's take the necessary preparatory steps, let's supply the documents. Hopefully, Holman, Fenwick and Willan will now pull finger and open the account and be able to pay tomorrow or the next day. So when, my lady, you put to me, is it sensible to regard the clause 2.2 precondition as waiving, or does that make a nonsense of the contract? The answer is it's perfectly sensible, because they come under an obligation to pay the deposits to HFW. It happens that because of their breach, they can't do that, but they're perfectly able to rectify that if they get on with it. And in the meanwhile, they're exposed to the contract being cancelled, but in most cases of running late, cancellation doesn't ensue. So the answer is yes, different ways of expressing the rule may be more apt to deal with different cases, but no, we certainly wouldn't accept that there was any anomalous or unbusinesslike consequences flowing from treating the requirement in Clause 2, Roman 2, that HFW give its approval as being waived.
And the follow-up question is, do you draw any material distinction between those alternative formulations, all of which you're referring to?
We subscribe to Lord Justice Rix's view expressed in Abacha that waiver sounds more English and more in accordance with the legal traditions that we as English lawyers are all familiar with. That is, when compared with deemed satisfaction, but that they are both just ways of arriving at the just result. So materially no, although if you asked me to use one phrase and stick with it, I would stick with waiver.
You don't like estoppel?
I love estoppel, of course I love estoppel.
Or even quasi-estoppel.
Or even quasi. No finer form of an estoppel than a quasi-estoppel, I think you'd agree.
I mean, it may be, it may not matter that historically the way in which this arose was in the, as so often in the common law, and the rules of pleading, and that, as you said earlier, if you plead a claim for money, and it's for the defendant to plead, but that's subject to a condition precedent, and it's not condition precedent's not being fulfilled, and then you, in your replication, say that's not open to you, that plea is not open to you,
Precisely.
because blah blah blah. That doesn't really look like a fictional fulfillment or a waiver, but just a rule of pleading that you can't plead something where it's your own fault.
In the context of, I said to you, there were two ways of analysing the way in which the obligation accrued. One is the historical narrative on this day, after the lapse, the deposits fell due. The other was the atemporal, the retrospective pleaded base analysis. In the context of pleading, estoppel makes more sense. In the context of the historical narrative, waiver makes more sense.
And in the authorities, insofar as Lord Watson's judgment in Mackay and Dick is concerned, and is followed through in some of the authorities, the expression is quite clearly deemed fulfilment, having its origin in the Scottish law principles, in Bell's principles and Puttier in Roman law.
Yes.
So that
Yes.
if one's looking at it as a matter of authority rather than analysis, there's no doubt that there's one strand of the authorities which is deemed or fictional fulfilment.
Precisely, and which is of course reflected in both Lord Justice Ricks's judgment in Abacha and in the way the tribunal expressed it in their award. Having opened up the wide field of waiver and estoppel, I also just want to lay down a marker about a third and more radical alternative, which is that it might be argued that the Abacha principle operates as a principle of construction. Now, that's not how the matter was expressed in any of the cases in which we principally rely on. However, of course, it's very well known that in other contexts, the principle of construction, that a party can't take advantage of his own breach of contract, has been said to have far-reaching effects. And we may at some stage look at Little and Courage, where Lord Justice Millett, and I don't know, Lord Justice usually nods this thing, but there was a brewery tenancy, and the tenant was entitled to an extension of the lease if the landlord had supplied a business plan which had been agreed with the tenant, and the landlord never did. And when the tenant said, "Can I have an extension of the lease?" He said, "But I haven't given you a business plan. We haven't agreed it." And Lord Justice Millett said, "Well, of course, we have to construe this in a just way, so we'll just insert the words 'if required,' by the way." And that just knocked out the whole precondition. And of course, in this case, it would be perfectly possible to achieve the same result if you read Clause 2, Roman 2, as prefaced by the words, "unless wrongfully prevented from doing so by the buyers." Right, so pay will be paid, and the second provision is that, the second precondition is that the stakeholder must have given its confirmation, unless wrongfully prevented by the buyers. And I mean, we'll see. We don't positively advance a case that the time has come to shake off the principle of law approach, which in our submission is reflected in the cases on which we rely. But if we were driven to it, it's a perfectly defensible and sensible conclusion that Clause as a matter of construction, clause 2, Roman 2, should not apply in circumstances where by their breach the buyers have prevented that precondition from taking effect.
And is that in line with what Lord Diplock said in the Privy Council case, Newton, that Mackay and Dick is a principle of deemed fulfilment, but it doesn't always apply, and you've got to look at the nature of the conditional obligation and construe the conditional obligation to see whether it does or doesn't apply in a particular case?
Yes.
Which, as far as I can see, is an approach which is sort of on its own so far as the authorities are concerned.
Yes, it is. It is an analysis which a scholar might say works better if the whole doctrine is transposed into a rule of construction, where you can say, well, I'm construing it to give effect to the policy of the law, which is that the wrongdoer, contract breaker, shouldn't be able to take advantage of his breach. But obviously that construction exercise has to take place in the relevant contractual context, bearing in mind the terms of, but that principle as articulated in Newmont is not inconsistent. I mean, well, the approach taken by the Privy Council in that case, not inconsistent with it being a rule of law, because if it's a rule of law that a party in the relevant circumstances can't rely on the consequences of his own breach, that has to be applied equitably and in the light of the consequences of the application of the rule. And it may be said, well, collies are very, this is the case of the FOB seller who was prevented from shipping and so delivering the goods by the breach of the buyer. He says, well, I'd like to rely on Mackay and Dick and claim the price, please. And what Mr. Justin McCarty says is, no, the rule can't be applied to a sale. The Mackay rule can't be applied to a sale in circumstances where you've not delivered the goods. Actually, it then goes on to say, can be applied as soon as you have delivered the goods without qualification. But that may be an example of where the rule of law approach is limited by the terms of the contract and the impact of applying the rule in its particular contractual context.
But when you phrase the third and more radical alternative as being that the principle operates as a principle of construction, I'm not sure Little and Courage is an example of that. It's you construe what the contract means, and if you construe it as Lord Justice Millett did in that case, there's no room for the principle to apply at all. There's simply been there was no precondition as
well, there was no precondition in the relevant event being the breach by the brewery of its obligation to present a business plan.
But the condition in that case was presentation of a business plan.
Yes.
If you construed that to be a condition which only arose if a business plan was presented, then the condition fell away, as it were. It's not using construction as a principle, whereas I think Lord Diplock was in Newton, and you were in your example of how you could apply it in this case as saying, unless wrongly prevented from doing so by the buyer. Yeah. That is introducing the rule as a matter of construction, and then applying the contract in accordance with its proper construction. That's
it's,
slightly different, isn't it, from what was happening in Little and Courage? But that may be what Lord Diplock was saying you can do in Newton, and that's why Mackay and Dick isn't a universal principle that applies to all contracts. You've got to construe whether it's a principle which the parties meant to apply as a matter of construction to the particular condition
and
in each case.
I accept that, and we'll no doubt look at it in due course, but it's a very famous passage in Alcacer, where what Lord Jauncey says is it is not taken to be the party's intention that a wrongdoer should be able to take advantage of his own breach, and that precept is then applied in the construction of the lease in that case, but it proceeds from a precept or understanding of the parties, or presumption about the party's contractual intention. And in this case, we say the same. Parties can't have intended, when they concluded this arrangement, that the buyers could shove a stick into the spokes of the deposit holding arrangements and then escape any responsibility for providing the deposit, except insofar as they may be exposed to damages for delay.
But that means you are in effect applying principles of construction, thinking about the intention of the parties.
I introduced that as a third alternative. So I've said
I've got 4 alternatives. I've got deemed fulfilment, waiver, estoppel, and construction. So are the first 2 the same? Is it waiver stroke fulfilment? They don't seem to me to be.
Well, my lord, the way in which we would put it is the principle applies either as a rule of law,
Yes.
as an equitable principle, and once you say that, the nomenclature of deemed satisfaction or waiver doesn't make any material difference. I fully accept the point that, my lord, you made about whether estoppel is more apt to a pleading analysis as opposed to waiver to a historical narrative analysis. But estoppel then, as the third alternative, is just another version of an equitable principle. The fourth, you're right to give it that number,
Is construction.
is construction, and that I put as I think I labelled it a more radical alternative.
Yes. Can I pick you up at some stage? This may not be the most appropriate one. Equitable. Why equitable? These are common law rules, aren't they? I mean, they're not rules applied in the Court of Chancery and not known to the common law courts. Why do you call it equitable? You might like to think about that. I noticed it in your skeleton. It just doesn't seem to me to be a peculiarly equitable principle at all. It's a rule of common law. I mean, the oldest case we got, Hotham, that's not a Chancery case, it's a straightforward case for damages for breach of covenant at law.
Unless the tribunal were right to say it's the same as the maximum inequity of deeming to be done that which ought to have been done.
I will.
Which is an equitable principle.
I will.
It may not matter at all, but since we're discussing the jurisprudential basis, I just quibble.
Yeah.
I think there's a tendency sometimes for people to use equitable as a sort of shorthand for something that isn't obviously there in the contract, and I'm not sure that is historically or jurisprudentially correct. But
I will reflect on that and ask Mr. Hayne what the answer is.
The reason that may matter is your point that if this is a rule of principle or rule of law, I think you accept that you need some sort of dividing line. It's not going to apply in all cases. It doesn't apply
No.
where the goods aren't delivered and you can't
or
claim
the
them.
or the service is not provided.
So you've got to find some principle, some basis on which you demarcate the extent to which that principle applies. Now, I think you may have been introducing the word equitable with that in mind, but as my lord says, I'm not sure it is a principle of equity. So if it isn't, you need some other basis to describe the principle in a way that doesn't have far-reaching effects that you accept shouldn't
Yes.
be the case.
You,
And
I know you
one
abs-
answer to that might be the more radical version.
yeah, I think what I would first say about the proposition that, unless carefully formulated, this principle, the Abacha principle, is capable of having far-reaching effects, which it can't sensibly be taken to have, is a point that we answer first by saying, as we formulate it for the purposes of this case, we simply say that this case is on all fours with Panamina and Corey, and it's specifically a case about preconditions which consist in preconditions which are concerned with approvals or other steps that have to be taken by a third party, and circumstances in which the contract breaker prevents the third party from fulfilling the condition. So we see, in the particular circumstances of this case, we are narrowly within an established case law. It may very well be that the Mackay-Abacha principle is capable of wider application in wider circumstances, and the process of the common law is to see to what extent those principles can be applied to the factual situations that arise. But one of the features of this particular case is it's just so close to the authorities that we say are relevant that it's not a case in which the potential demerits of a widely formulated principle arise for consideration.
But in answer to my lady's question, the only one of your four alternatives which would provide a principled basis for applying the Abacha principle in some cases, i.e. these, but not in others, payment of price and delivery and so on, would be the fourth of those, that it's a matter of presumed intention of the parties as a matter of construction, and that, as Lord Diplock said in Newton, it is a principle which applies in some cases but not all places, and it's a matter of construction as to whether the parties intended it to apply in this category of case, in this case in particular, but that may be category by category, so that the reason that Colley and Haywood was decided as it was and is regarded as sound law in relation to delivery and price is that although the delivery is a condition precedent to entitlement to the price, put in simplistic terms, so it would fit into a Mackay and Dick Abacha principle in theory. Those sale of goods cases dealing with price and delivery must be taken to be ones in which the parties did not intend such a principle to apply because of the ramifications in the sale of goods context.
Can I give two answers to that? One is Lord Diplock and Newmont, which seems to suggest
Sorry, I'm calling it Newmont, quite right.
Newmont, it seems to suggest a hybrid approach of applying a rule of law in a way that has regard to the terms of the contract. But second point, the way in which we have formulated the abacha rule as a rule of law is that in order to engage the principle, the claimant must have done everything that he needs to do in order for the debt to accrue due. Right, and can I just make a distinction here, which may come into the argument at a later stage? People, in the context of talking about the accrual of debts, quite often talk about whether the debt has been earned or not. And then they also talk about whether the debt has accrued or not. And you might make a distinction between the situation in which the creditor has earned the debt because he's done everything that he has to do in order for the debt to fall due, but it hasn't, in a strict sense, accrued because it's still conditional on something. So, for example, the seller might have, or the builder might have done all the work, but it's still conditional on the approval of the employer's surveyor. And if you attempted to take up that linguistic distinction, our submission about the scope of the rule of law, that is the abacha principle, is that the claimant must have earned the debt, i.e. must have done everything that he can do, he is required to do in order for the debt to accrue due, but it doesn't have to have accrued, that is, it doesn't have to be unconditional. Not all preconditions have to be satisfied. Maybe that Holman, Fenwick and Willan still have to give their approval, say that the account is open. And that does provide a principled basis for explaining Colley, because in Colley and similar cases, the seller has been unable to earn the price because he hasn't been able to do what he has to do, which is to deliver the goods on board the ship.
Well, I understand you say that is a distinction, but I have some difficulty in why that should be a principled distinction as to when the abacha principle and does apply and doesn't apply, given that in those cases the underlying principle that you shouldn't be entitled to rely on your own wrong is that the party would be relying on their own wrong to prevent the innocent party saying the debt has fallen due.
The question slightly begs the question, what is a principled basis for limiting the rule? But perhaps I should use the term a coherent and pragmatic way of explaining and limiting the rule, because in the case where the creditor has done everything that is required of him, has in the jargon that I've proposed, earned the debt, the abacha principle is doing a limited amount of work in discharging other conditions which the debtor is preventing from being fulfilled. But, and by that means, avoiding what the real vice of the Colley situation was perceived to be by Mr. Justice McCarty, which is that the lucky old seller ends up with both the price and the goods. That was the sticking point for Mr. Justice McCarty. Can't be right that and it's not reflective of the policy of the law as expressed in Section 49 of the Sale of Goods Act, that the seller can have both the goods and the price.
Can I suggest, my lord said that only the fourth explanation provided some principled basis. Can I go back to my suggestion, but it arises out of the common law rules of pleading. If you were suing for the price of goods sold and delivered, you'd have to say that you delivered the goods. So if you can't say, the plaintiff would have to plead, I've delivered the goods, sold and delivered the goods.
Yes.
Or alternatively, it's one of those contracts where there's payment of the price becomes due before delivery and so on. But the normal count would be for goods sold and delivered. So the plaintiff would have to plead, I've delivered the goods. So if he can't do that, all the defendant has to do is deny it. He doesn't have to plead a condition. I mean, in a sense, obviously, delivery is a condition precedent, but it's not for the defendant to raise as a condition precedent. It's for the plaintiff to prove as part of his cause of action. And there is a difference between something the plaintiff has to prove as part of his cause of action before he has a claim at all, and something where the defendant has to raise a condition precedent, which
again,
might be
might be
an
good reason for saying
alternative principled basis for getting to the what we all, I think, accept as the right answer. That in McCarty's, Mr. Justice McCarty's case.
I accept that. Okay, so I had got as far as
I'm sorry, we're interrupting you.
No, I'm not no way to rush you. I had therefore made a number of complaints about the formulation of the question, not with a view to complaining about any procedural defect in this case, but only so that we're not misled or confused by the terms of the question as to what the real issues are. And I won't repeat them, but except to say very briefly, it's one, that the relevant condition didn't have to be fulfilled by the buyers. The second was the debt. The operation of the principle is not to create a debt claim, it's to create or to render effective the buyer's obligation to pay the deposit to the stakeholder. And the third was the one we've just been debating at length, whether deemed fulfillment it's correct to only cast the question in terms of deemed fulfillment, or whether sellers' options 2, 3, and 4 should also be on the table.
Can I, whilst we're dealing with what's
that?
While we're dealing with what's in the arena, can I raise the question of distinction between accrual of a debt and mere payability of a
Yes.
debt? The way, as I understand it from the way that the tribunal addressed your arguments before the tribunal, there were two different ways of approaching the clause. One was that the contingency, the condition, was a condition precedent to the accrual of the entitlement to the deposit.
Yes.
And that's what we've been focusing on.
Yes.
The alternative was that it was only the machinery of payment, if I can put it that way.
Yes.
Well, I think that's the way it was put below,
It
which was an analysis that the debt accrued and the condition only affected payability, and that was rejected by the tribunal, and I don't think has resurfaced in the arguments, has it?
Okay. It was not dealt with by the tribunal. I think I'm right to say.
Right.
I'll apologise if I'm not.
No, well, anyway,
But it was not dealt with by the tribunal, and I don't want to be like the magician who sort of pulls back to reveal his own sleight of hand, there was a defect in the argument. The argument was, under clause 2, the deposit becomes due when the contract is signed, and the whole business of the deposit holder and HFW opening an account was all just machinery for effecting payment. If that were right, it would be a precondition to payability. Right? That's where you end up. The debt of the deposit has accrued due on signing the MOA, and the actual obligation to pay is postponed until the condition as to the opening of the account is satisfied, and then you've got 3 days to actually do the paying. The problem with that is, if it wasn't payable until the satisfaction of the precondition, then we couldn't cancel under clause 13. Bear in mind, this is an alternative to a batcher. I mean, it could be an intermediate case where you say it accrued due, it wasn't payable, we rely on a batcher to render it payable, and once it was due and payable, then there was a default by the buyers and we could cancel. But and that would be a perfectly coherent case, but it wouldn't be adding very much to our primary case, which was a batcher made this payment due and payable.
But I thought the tribunal did expressly reject the idea that it accrued due on signing the MOA.
The judge did.
The judge did, sorry.
But did the judge not draw a distinction for the purpose? I mean, she accepted there is such a thing as the principle, although I don't think she accepted it as set out in a batcher. But there is a principle, undoubtedly, and she said that it only applies where debt had accrued, and in your case the debt hadn't accrued, isn't it?
I mean, she said of the cases that we primarily rely upon, which in front of her were Panamina and a batcher, because at that stage the industry of counsel had not discovered Corey. So this is Corey is new for you. But she said of those two cases, well, certainly of Panamina, that was a case where the debt had accrued due and the precondition was to payability.
Exactly.
And therefore the operation of the principle was only discharging a condition as to payability. And then she said to me, with respect to our alternative case, it had accrued due and wasn't payable. No, but you're wrong in your premise. In other words, you're wrong to say that it had accrued due on signing and was only payable. I find that it hadn't accrued due at all. So that's as far as the case went. But why I say it was a defective case in front of the tribunal was because in front of the tribunal, the buyers were not arguing that, as the judge below concluded, that there was a principle and a batcher principle, but it was confined to preconditions to payability. They were just arguing there's no batcher principle, and anyway, as you see from the award, the real gist of this is we didn't cause the condition not to be satisfied because you'd failed to supply the documents yourself. So in front of the tribunal, the distinction between accruing due and payability wasn't critical to the success of our case. And the as I say, the case was at least unless you accept that there is an abatur principle which applies to preconditions to payability, the argument that the debt accrued due didn't get us home on clause 13 because the riposte to it would have been, okay, so it accrued due when you signed and it never became payable. So we needed to win on abatur even on that alternative case. It wasn't a true alternative case. If we'd lost on abatur and the tribunal said no abatur principle, we wouldn't have been able to get home on the it accrued due but was payable later, because the right question then would have been, well, are you saying it ever became payable? How did it become payable? It would only really have helped us if we'd won on common law termination, so that the MOAs were common law repudiated by the buyers, and we could then say, but we had an accrued but not yet payable debt, and we were entitled to recover that. Even that would have been. But I started this because, my Lord Justice Popplewell, you asked, how does this fit in? The answer is, it wasn't dealt with by the tribunal. Insofar as it was relevant in front of Mrs. Justice Dias, it was only relevant on the hypothesis that she was right to say that there is an abatur principle, but it is confined to preconditions to the payability of accrued debts. That point failed in front of her because she said the premise of the argument, i.e. that it accrued due on signing of the MOA, is wrong. As Mr. Eaton has pointed out, there's no appeal against that conclusion.
No. So what I was feeling my way towards, and I think you're confirming, is that in order to succeed on the appeal, you have to establish the applicability of an abatur principle to the accrual of the debt obligation.
Precisely, and we accept that.
Thank you.
Right.
Thank you.
Authority in favour of the abatur principle. Just so you can see where we're going with this, we say there is authority that supports our proposition that the abatur principle applies in this case, and we rely on Amina, Cora, Corey, and abatur, and then we're going to say, and anyway, that conclusion is consistent with principle and justice.
So not Mackay and Dick.
Mackay and Dick does support us. We've set out in our skeleton exactly how we analyse that case. I will answer any submission to the contrary made by Mr. Eaton. But in circumstances where there is more recent English House of Lords, Court of Appeal, and first instance decisions, I don't need to go to Mackay and Dick, although I will, if necessary, say that it supports us. I'm going to look briefly at Mackay and Dick in the context of some of the academic criticisms of the abature principle, which sort of found on the facts of Mackay and Dick. But if I may, I'll reserve what I have to say about Mackay and Dick for reply.
Right, thank you.
Panamina. Panamina is authority, in our submission, for the proposition that where a party's obligation to pay a debt is subject to a precondition that a certificate or approval be obtained from a third party, and the supposed the putative debtor wrongfully prevents the third party from providing the certificate, the requirement for the certificate is waived or dispensed with. Right, now, we've got Panamina in the House of Lords, tab 8 of the original authorities bundle, and we've got the Court of Appeal decision at tab 8 of the supplementary bundle.
Can you, I'm sorry, read your proposition again?
Yeah.
Where a party's obligation to pay a debt is subject to a precondition.
A certificate or approval
Yeah.
be obtained from a third party,
And
the, I said supposed, but I also said putative debtor wrongfully prevents the third party from providing the certificate or approval. The requirement for the certificate or approval is dispensed with.
thank you. I think you said
Waived or dispensed with.
with.
I said waived or dispensed with. What did I say this time?
You just
You just said dispensed with, but
I stick to waived. Hazards of oral presentation. The case concerned the repair of a ship which had been sunk in the Thames, and having been sunk was raised and sent for repair.
are we going to go through it in the Court of Appeal first, or
Let's do
House
that.
of Lords?
Yeah, please.
It's helpful to have it in front of us.
So tab 8 of the supplementary bundle. The terms of the repair contract are at page 114 of the report. That's 228 of the bundle. And the critical term is clause 7, page 228. The owners shall pay for the repairs upon the ordinary commercial basis, i.e. labour plus 25% thereof for establishment charges, plus cost of material, plus 10% on profit on the total of these three items, plus subcontracts and cash disbursements, plus 5% all old material except heavy parts of machinery to become repairer's property. I'm sure this court would immediately recognise those as the usual commercial terms. Payment shall be effected as required by the repairers on the basis of cash against expenditure during the progress of the work, and the ascertained balance on completion of the repairs, and every such payment, shall be effected promptly by the owners after the issue of a certificate by the owner's surveyor that the work has been satisfactorily carried out, and on receipt of a certificate of the amount due issued by the Costs Investigation Branch of the Ministry of War Transport, and certifying that the same has been checked and found correct. So that is a provision envisages payment on the particularly complex basis that is described, payment made continuously as work goes on, payment as required by the repairers on the basis of cash against expenditure during the period of the work, and then subject to two conditions to payment. One is a certificate from the owner's surveyor, and the other is a certificate from the ministry's costs investigation branch. And the ministry separately undertakes, by the terms of this contract, that its cost investigation branch will issue the necessary certificates. The yard's claim was for £21,000 for work done completing the repairs, and that claim was reflected in 3 CIB certificates that had been issued, the last of them in April 1942. The owners refused to make the payments demanded, relying on the fact that their surveyor, Dr. Telfer, also happened to be the president of the company, had refused to provide his certificate, and you see that pleaded at page 115, 229 of the bundle, at the first hole punch. Defendants denied the money was due. They said it was a condition precedent to the plaintiff's right to receive any payment that a certificate should be issued by the defendant's surveyor that the work had been satisfactorily carried out. No such certificate had been issued. The yard sued for the money, and its claim succeeded at first instance in the Court of Appeal and in the House of Lords.
The claim was framed in debt and alternatively in damages, wasn't it?
I think that's right.
I got that from the bottom of page 122 of the report. Bottom of column 1. And I think it's also in the head note to the first instance decision.
Yeah, exactly. The first dispute between the parties was as to what the respective roles of the owner's surveyor and the CIB were, i.e. what each was supposed to be certifying. However, at all levels, the courts held that the CIB was concerned with cost and the owner's surveyor was charged with certifying quality. And you get that neatly from Lord Justice Scott's judgment at page 100. .23, column 1. He says, I'm of the opinion that the function assigned by the contract to such surveyor, as the appellants might point, is limited to considering and passing upon questions of quality, for example, in respect to materials and workmanship, as and when the work was carried out. Lord Thankston in the House of Lords took the same view, and you find that, I'm not going to ask you to turn it up, but you find that at page 108 of the report of the House of Lords decision. From that starting point as to the relative respective roles of the surveyors, the critical conclusions that Lord Justice Scott reached are at page 124 and they can be summarised in 4 points, essentially where the red lining is directing your attention. One is the owner's implied duty to ensure that their surveyor performed his agreed function. Second, in breach of that duty, the owners had failed to keep Dr. Telfer on track, bottom of the page. Third, top of the next column, that was a repudiation of the contract, but also, and critically, right hand, top of first paragraph of the right hand column, on the principles of Mackay and Dick, and also of Hickman and Roberts, the claimants were entitled to treat the defendants as preventing the performance of the term of the contract in question, and also as waiving it as a condition precedent to the plaintiff's right to sue on the costs of investigation branch certificate. Now, Hickman, you haven't got in the authorities bundle. It's a slightly different case. It's to do with arbitrators who collude, and essentially that aspect of the reasoning of the Court of Appeal was rejected in the House of Lords. Doesn't take us any further than, so that's why you have that slightly.
It formed quite a major part of the first instance judgment, which
Exactly.
was very critical of the honesty of Dr. Telfer and Mr. Chandris.
Exactly.
But that then disappears by the time one gets to the House of Lords.
So on that reasoning, we invite you to hold. This is a decision which the Court of Appeal have concluded that a party who, in breach of contract, wrongly prevents a third party from providing a confirmation that would satisfy a condition precedent to a debt, the condition in question can be treated as waived, or it may be otherwise dispensed with. In the House of Lords,
Just before we leave that, there's an at 126 column 2. There's an alternative ground that Lord Justice Scott gives. Just at the first main
second alternative
the
for
second
dismissing
alternative
appeal.
ground for dismissal
Yeah.
is, and this essentially is a damages for breach analysis.
Yeah.
That there was a breach in relation to what Dr. Telfer did, and they ought at once to have dismissed him, and failure to do so would, in my opinion, clearly constitute repudiation, entitling the plaintiffs to recover under the head of damages, and also under the prevention of performance principle. So there's that alternative
No other
in
means.
Lord Justice Scott.
Yes, although again, coming to the conclusion that the prevention of performance gives rise to a waiver of the condition precedent.
Yes.
All right.
So sorry to hold you up, but do we also need to look at what Lord Justice Goddard says? Because that, I think, is adopted by Lord Thankerton. And he does at the top of 127 put it on the prevention principle. I think 4 lines down, column 1, page 127.
Yeah, I dancing about was going to come back to this in
Sorry,
the context
I'm
of
sorry,
it. No, but
I'm sorry.
let's look at it now, and let me just say, yes, we rely on this, and in particular rely on. So he agrees with Lord Justice Scott and says, I'm in entire agreement with him. First question that arises is, can the defendant rely on the absence of a certificate from their surveyor, the production of which condition precedent to their liability to pay production, which is a condition precedent to their liability to pay, when the absence of that certificate is due to a refusal by their surveyor to perform the duty assigned to him by the contract, it is and must be conceded that if a party desires to rely on the non-performance of a condition precedent, he must do nothing to prevent the condition from being performed. And if there is anything that must be done by him to render possible the performance of the condition, a failure by him to do what is required disentitles him from insisting on performance of the condition. That puts it in a more far-reaching terms than Lord Justice Scott's. If that's right, it's right, but we don't have to rely on, in order to justify the tribunal's decision, that slightly more far-reaching way of putting it.
What is more far-reaching about it? I'm sorry, it's being slow.
Well, it doesn't. It doesn't depend on the prevention being a breach of a contractual obligation.
Two respects. It might, first of all, it doesn't rely on that, and secondly, it might be said that the at least as it's put in the second sentence, that it's not. It's merely supposing hindrance of the fulfilment of the precondition rather than prevention of performance of the precondition. Do nothing to prevent, and if there's anything that is done by him to render possible the performance of the condition, that must be done by him to render possible the performance of the condition, a failure by him to do what is required disentitles him from insisting on performance of the condition. So put like that in that final sentence. If you fail to do what you have to do in order for the condition to be fulfilled, you're then barred from relying on the precondition, and that way of formulating it wouldn't admit the argument that we had in this case, which was, but it wouldn't have been fulfilled anyway. I mean, perhaps not too much should be hung on an explanation, and I mean, where I'd like to hang my submissions on the beginning of that sentence, where he says if you prevent it, you can't rely on it. But that slightly wider formulation is not something that is in any way essential to our case.
I'm sorry to have taken you out of your turn.
In the House of Lords, so that's tab 8 of the main authorities bundle. The question arose, House dealt with the question whether the owners could rely on the absence of Dr. Selfer's certificate. And Lord Thankston rejects that proposition, and the words that we particularly rely on is that we said that Dr. Telfer's insistence that he was entitled to go into matters other than quality was an illegitimate condition precedent to any consideration of the granting of a certificate. He then says, second last line, it's almost unnecessary to cite authority to establish that such conduct on the appellant's part absolved the respondents from the necessity of obtaining such a certificate, and that the respondents are entitled to recover the amount claimed in the action. And then he refers to Possum And then again, we rely on the end of this paragraph. He says if the defendants had done their duty, they would have had to appoint another surveyor who's prepared to stick to his role. And if they refused to do so, second hole punch, the respondents would have clearly been absolved from the necessity of obtaining the surveyor's certificate. The respondents are equally so absolved when the appellant's wrongful view of their surveyor's function under clause 7 prevents the appellant from obtaining the certificate. I agree with the view expressed on this point by Lord Justice Goddard.
Is absolved just another synonym for waived?
Yes,
It's a different way of putting the same point.
we say exactly that.
And in the passage cited from Hotham, what Mr. Justice Ashurst has said is that it's equal to performance,
Deemed, which is
which is
deemed satisfaction.
deemed satisfaction, deemed fulfilment.
Yeah. Our short submission is that the facts of the Panamina, or the facts of Panamina, the IW wing, can't sensibly be distinguished from the facts of our case. The judge didn't accept that submission. She distinguished Panamina on the basis that Panamina was a case dealing with an accrued debt subject to a precondition as to payability. At paragraph 67 of her judgment, which is in page 33 of the bundle, she says, again, however, Panamina seems to be in the case that the amounts that had accrued due by virtue of the CIB certificates, and that the surveyor's certificate was simply a condition precedent to payment. Right, now, we make two submissions in response to that conclusion against that. The first is that Panamina was not a case where the amounts owed to the yard had accrued due by virtue of the CIB certificates. And secondly, even if it were such a case, there's no sensible, principled reason to treat differently preconditions to the accrual of a debt and preconditions to the payment of an accrued debt. Okay, so submission 1, in Panamina, the owner's debt didn't accrue by virtue of the issue of the CIB certificate. What the judge has essentially concluded is that upon the issuing of the CIB certificate, we are dealing with a debitum in praesenti, solvendum in futuro. That is an expression which is used to describe a credit arrangement. That is a case in which there is an unconditional debt except that it's not immediate, it's to be paid at a later date. It's unconditional except that it's to be paid at a later date. The simplest debitum in praesenti is a loan. I lend you £10 and you agree to pay me back in 1 week. The second and wider case of a debitum in praesenti is where the buyer of goods and services is given credit. The parties agree that the buyer owes £10 as from day one, but only has to settle 5 days later or a week later. That second situation, buyer of goods and services given credit, was the position in the Dominique and in the Karen Vartis, where there were clear express terms, clear express contractual language, saying this debt is earned as of this day and will be settled at some later date. But all such cases involve two characteristic features. One is the debt is unconditional on day one, except as to time of payment. It's not contingent, it's not dependent on subsequent events. And the second is that the parties fix both a date of accrual and a subsequent date of payment.
Do they need to? If I lend you money without any, and say that it can be demanded at any time after the lapse of a year, there's no fixed date for repayment?
Your example is a good one. I don't intend to say it has to be a fixed time, but it's in the nature of the a debitum in praesenti solvendum in futura date, that obligation, that a time, even if it's a variable time, a subsequent time for payment has to have been specified. So in your example, the relevant futura in which the debt is to be solvendum is after a year. If I simply say, I lend you £10, I suppose if I said, and you must pay it back to me whenever I ask, the relevant futura is upon my making a demand, and it's not payable now.
Strictly speaking, I think at common law, a debt payable on demand is payable immediately.
Yeah. Okay. Well then,
for limitation purposes,
yeah.
It used to be anyway.
Okay. Well then, that's a bad example.
But I have to point that it has to be something that's not immediately payable.
There has to be a postponement of the debt.
That's probably a better formulation than saying you have to specify in advance when it's payable.
I will take that formulation. Those features of a debitum in praesenti arrangement are to be contrasted with the ordinary position where if parties agree that an obligation to pay money is conditional on performance or other contingencies, there is no debt until the relevant performance or contingencies have occurred. And I won't take you there, but there's an extract from Chitty in the enormous textbooks bundle at tab 30, page 487, which says, well, actually now I've spent so long on it, let's just go there. Tab 30. paragraph 31, so lucky I did. It's paragraph 31.003.
Page.
Page 487.
Thank you.
So a debitor and presentee is characterized by a credit arrangement under which the parties have agreed that a debt is unconditional on a particular day, but the payment is to be postponed. The general position outside such arrangements is that if a debt is conditional, there is no debt, no accrued debt, until any conditions have been satisfied. Now one looks at Panamina and says, well, hang on, which of these two positions are we dealing with here? And did the parties, by specifying two certificates, one by the CIB dealing with cost, and the other by the owner's affair dealing with quality, seriously intend, can they be taken to have intended, that upon the certificate dealing with cost, there should be an unconditional debt, which is not payable until the certificate dealing with quality is issued. That would be a very surprising arrangement, because it might be said immediately, well, hang on, what if the work's absolute rubbish? I mean, why should I have a fully accrued, unconditional debt of £1,000 for work done if in fact the work is of rejectable, inferior, unacceptable quality? Secondly, if you are intending to create a credit arrangement under which the debt is unconditional when the CIB issue their certificate, but not payable or is postponed until the quality certificate is issued, you would expect to see that an arrangement under which the CIB certificate is issued first and the quality certificate issued later. But that doesn't seem to be what the parties have envisaged. Clause 7 simply refers to the two certificates in the same breath without in any way, either expressly or implicitly, assuming that one will be issued before the other. They are, on a ordinary reading, two simultaneous or concurrent conditions of the owner's obligation to pay. Thirdly, unlike the Dominique or the Carambatis, there is no wording in relation to the certificate that's to be issued by the CIB that any debt is to be unconditional upon that certificate being issued. In the Dominique, the relevant charter wording says freight is earned on shipment. There's nothing in the wording of clause 7 to suggest that the right to payment for repair services is earned on the issue of the certificate by the CIB, albeit not payable until a quality certificate has been issued. So three things. It's commercially nonsense to suggest that there could be an unconditional debt prior to the certificate from the quality surveyor, because no user of the yard would be expected to have an unconditional debt for work that was of inferior or unacceptable quality. Secondly, there's no order to the two certificates suggesting that one is the owner's surveyor's certificate is the postponed occasion for payment of the earlier certificate. It seems that the two certificates might be provided in any order. And thirdly, there's no wording making the debt unconditional upon the issuing of the CIB certificate. We add 2 points to those three fundamental observations about the terms of the contract in the Panamina. One is, there was no suggestion in any of the pleadings or the argument or the judgments in the Panamina that the issuing of the CIB certificate was supposed to give rise to an unconditional obligation to pay, and that the owner's certificate was only concerned with the time of payment. It's been suggested for the first time that that was the position in the commercial court in this case. And secondly, there's no basis in common law or the case law relating to contracts of this kind for the proposition that the judge accepted. And we, in that context, relied in our written skeleton on Dunlop and Hendel Steel, which is a case that you find at tab 12. I'm conscious that it's 3 minutes to 1. I think I can probably show you Dunlop and Hendel Steel before.
Yes, do.
The case is at tab 12. This was a case in which there was a main contract between the client, who was MPL, and a principal contractor, who was Pilchers. And the contract between MPL and Pilchers was a lump sum contract on a REBA form, which envisaged interim payments on account of the lump sum that would be earned when the construction was finished. There was then a subcontract between Pilchers and Hendel Steel, under which Hendel was going to supply Pilchers with steel construction work and materials. And that was not a lump sum contract. That was a contract for work and materials plus uplift. Hendel Steel was a judgment creditor of the claimants Dunlop, and Dunlop attempted to garnish debts owed by Pilchers to Hendel.
You said Hendel Steel was a judgment creditor.
Yes, did you mean judgment
Creditor.
debtor?
Judgment debtor.
Judgment debtor. Dunlop attempt to garnish debts owed by Pilchers to Hendel. And that turns, we said in our skeleton that debitum in praesenti is a concept that allows the law to act upon the obligations, or to act upon a debt prior to the debt becoming payable. Garnishment is one of the typical ways in which garnishment and assignment are ways in which currently non-payable debts may be the subject of legal action. And the question arose whether a debt had accrued between Pilchers and Hendel. And that question was addressed by the Court of Appeal, Lord Goddard, Chief Justice, and the relevant passage is at page 167. And the judge starts by saying, under this REBA form, there's no debt between the client and the principal contractor until the architect has issued his certificate. He then says at the second hole punch, 2/3 of the way down, the question in this case is arising between the contractor and the subcontractor, and their payment was on a slightly different basis. It was on a perhaps a significantly different basis. It was for work and materials. And then he says at the bottom of 168, it's reasonably clear that the parties meant in this case to put the subcontractors with regard to payment in the same position as the contractors. That is to say, they were to be paid on certificates. And for the reasons I tried to show with regard to the certificates which passed between the contractor and the building owner, there's a very good reason for it. This was a contract, as far as the guarantees were concerned, with the judgment of £19,000. It is to the advantage of the guarantees to have the contract providing for certificates in this way, because otherwise they'd have to deliver everything, do all the work before they'd be entitled to anything. So this, like Panamina, is a case where there is to be continuous payment during the lifetime of the contract against certificates. Under this provision, in my opinion, it's clear that if the architects issued certificates from time to time and included any of the subcontractors' work, they would, under the terms of the main contract, they would have, under the terms of the main contract, to show what was due to the subcontractors. Therefore, I hold that the issuing of a certificate by the architect is just as much a necessity for investing a cause of action in the subcontractors as it is in regard to the main contractors. And I think it's not a case of debitum in praesenti solvendum in futuro. It's a mere case of putting off payment. It's not a mere case of putting off payment. It's not a mere case, apologies. It's that judgment debtors do not have a right to be paid, and therefore there is no debt until there's a certificate certifying the amount that's to be paid for this steelwork. And we simply say, this is a contract which in all material particulars is the same as the Panamina contract. And the conclusion would be in this case that where payment is to be made in stages against it, there is no debt until the certificate is issued, is the right conclusion to draw about the contract in the Panamina.
So convenient moment. 2 o'clock.